Insurance law. Insurance law is the practice of surrounding insurance, including insurance policies and claims. It can broadly broken into three categories: regulation of business of insurance, regulation of the conduct of insurance policies, especially with regard to consumer policies, and regulation of claim of handling. Principles of insurance. Common law in jurisdictions in former members of the British Empire, including the United States, Canada, India, South Africa, and Australia, ultimately originate with the law of England and Wales. What distinguishes common law from their civil law counterparts in the concept of judgment law and the principle of in the concept of judgment law and the principle of stare decision, the idea at its simplest that courts are bound by the previous decisions of courts of the same or high status. In the insurance law context, this meant that the decision of early commercial judges such as Mansfield, Lord Eldon, and Bulwer Bonds, or outside England and Wales, were at the least highly persuasive to their successors considering similar questions of law. At common law, the defining concepts of a contract of commercial insurance is of a transfer of risk freely negotiate between counterparties of similar bargaining power equally deserving or not of the court's protection. The underwriter has the advantages by dint of drafting the policy terms of delineating the precise boundaries of cover. The prospective insured has the equal and the opposite advantages of knowing the precise risk proposed to be insured in the better detail than the underwriter can overachieve. Central to English commercial insurance decisions, therefore, are the link principles that the underwriter is bound to the terms of his policy and that the risk is as it has been described to him, and that nothing material to his decisions to ensure it has been concealed or misrepresented to him. In civil law countries, insurance has typically been more closely linked to protection of the vulnerable rather than as a device to encourage entrepreneurialism by spreading of risk. Civil law jurisdictions, in very general terms, tend to regulate the content of the insurance agreements more closely and more in the favor of the insured than in common law jurisdictions where the insurer is rather better protected from the possibility that the risk for which it has accepted a premium may be greater than that for which it had bargained. As a result, most legal systems worldwide apply common law principles to the adjunctions of commercial insurance